This podcast is brought to you by the School of Advanced Study, University of London.
A very good evening, everybody, and warm welcome to the seminar this evening. Thanks very much for foregoing a round of early Christmas shopping to join us here instead to hear about cessation of refugee status. Very much appreciated. I'm very, very pleased to welcome from afar, again, tonight, our guest speaker, Professor Maarten den Heijer. As many of you know, Maarten is one of the, I think, leading new scholars, certainly in the Netherlands, on EU asylum and migration law questions. And we're really very privileged to have him here with us this evening to address us on certain aspects of the law relating to cessation. Just to give you a little bit of background for those of you who are not familiar with his work, Maarten's a professor of international law at the University of Amsterdam, and he also serves on the Mayor's Committee of Experts on International Immigration, Refugee and Criminal Law, which is an organisation established in the Netherlands by academics to, in a sense, exercise independent oversight over some of the things that are happening in the EU asylum law context. Maarten previously worked in practice for a good deal of time as policy for the Dutch Refugee Council and as legislative lawyer for the Dutch Ministry of Interior and Kingdom Relations. And as most of you will know if you're familiar with his work, he works very, very broadly across many areas of EU migration and asylum law, and his focus in recent years has particularly been on issues relating to extraterritorial human rights obligations and asylum issues, particularly in the context of reform, as well as questions relating to diplomatic asylum, and most recently within the context of the SHARES project, issues of shared responsibility within international law. We're very fortunate that he's going to speak to us this evening on when refugee status ends, repatriation or integration, ? And of course this deals principally with questions of cessation in EU qualification directive and in implementation of that directive by EU member states. So without further ado, I'll hand over to Maarten. Thank you very much, Maarten.
Thanks a lot, David. Pleasure, honor for me to be here in London. I want to talk to you about cessation, indeed, and chiefly the question or dilemma what we should do with persons who are, technically speaking, according to the Refugee Convention, no longer refugees because they have become able again to avail themselves of the protection of their own country, for example, because it has become safe in the country of origin, and should be then indeed revoke their status and return them, or are there other durable solutions? And there are two reasons I'm currently doing research on this. It is work in progress, and David especially invited me to present work in progress. I also very happy to hear afterwards input and thoughts of you. And there were two reasons why I thought I should look into this topic. The first one is a legal technical one, which is the mandatory coupling of cessation with revocation of refugee status in the qualification directive. The qualification directive more or less says if there is no longer a protection need, a member state must revoke refugee status, and it also means that the residence term, the residence title, which is coupled to the refugee status, is terminated. I will come to that in a moment. Secondly, and more broadly, I think with respect to cessation, there is a paradigm shift going on, especially in the developing asylum, in the developed, so the Western asylum countries. I think that it's fair to say that for a long time, cessation was primarily an instrument used in the developing world, Africa, Asia, where UNHCR is often responsible for providing relief, for providing protection, where the sheer number of refugees and limited resources made repatriation the most desirable solution, if and when the circumstances allow for it. And this frequently occurs through general declarations of cessation made by UNHCR. For example, UNHCR declared that the refugee status should be seized in respect of refugees from Sierra Leone in 2008, from Angola and Liberia in 2012, Rwanda in 2013, Croatia 2014. And such a declaration, such a general cessation declaration of UNHCR will then generally initiate the process of facilitating repatriation, voluntary repatriation, or exploring alternative statuses allowing for local integration in the host country. But in the West, for decades after the adoption of the Refugee Convention, a different paradigm prevailed, and this was simply not to apply, or at least not to routinely or systematically apply cessation. The prevailing practice for up till now, you could say, in most Western states has been not to return refugees, not to check for cessation, and simply to allow permanent residence and naturalization as an automatic consequence of the initial grant of asylum. So once you're in, you stay in unless you engage in criminal activity. Not always, and there are all kinds of exceptions, but this was more or less the prevailing paradigm. It is changing. You can see that cessation is invoked more often. There is increased attention for cessation in policy, but also among academic scholars. I think that is for a number of reasons. And perhaps the key one is that there is an increased focus on the temporary nature of protection. And this is, of course, an attractive argument, especially when faced with large numbers of refugees. Temporary protection came up as a concept, especially in the 1990s, in response of the massive influx, as we said, refugees from Bosnia and Kosovo. And now, discussions in Europe as well with the Syrians. We will uphold refugee law, we will provide protection, but we do no more than is obliged by us under the Refugee Convention. That protection is temporary, and when it is possible, we will return the refugee. If we now look at the discussions in Europe on protection of Syrians, a key question in many capitals is what we will do when Syria becomes safe. And there are fundamentally opposing views. Sweden, I believe yesterday that their government fell, but I have a quote here from, I think he is the outgoing now integration minister, Mr. Uhlenhag. He summarized the Swedish approach to Syrians by saying, "We prefer to give refugees permanent residency immediately because it gives them a better feeling of home and can help them settle quicker." The way we look at it, he said, is if you give someone temporary residency, you send a signal to society that we want you to go home after a while. That feeling of living with your luggage in the hallway, waiting to go home, is no way to live. From an integration perspective, in the long run, this is a far more effective way to treat people. So in Sweden, a Syrian refugee gets permanent residence immediately. Denmark sees this differently. This summer it introduced a new bill which has not yet been adopted. Lots of discussions, debates going on in Denmark about this proposal for a new bill. The proposal says that we will introduce a new type of residence permit for asylum seekers, a temporary type of residence permit. It was adopted in response to the Syrian influx, and I quote now the Danish Justice Minister, Karen Hakkerup. She said, "The majority of refugees we see at the moment are not individually persecuted in their home country. Many of them come from areas in Syria where there are indiscriminate attacks on civilians, and we need to look at how we can ensure these people can be sent home as soon as conditions improve in the home country." Now the bill foresees in a temporary residence permit for specific categories of refugees, and those are mainly the persons who would fall under Article 15C of the Qualification Directive, the Sufi and Elmi type of generalized violence cases, so persons fleeing from civil war. And this new temporary residence permit would apply to that category. It says that the permit is valid for 1 year, and then a check is made for cessation. Is it possible, are the circumstances safe enough to return the person? Within that 1 year, no family reunification is possible. And if the country of origin remains safe after that 1 year, the permit is extended for 2 years, and then again the check is made whether the person can return home. We have a similar discussion going on in the Netherlands with one opposition party, the Christian Democrats, proposing something like the Danish system, a special permit for Syrian refugees with an emphasis on the temporary character, with a lower level of rights than we grant to genuine refugees. The government has advised against it for practical reason, but also other reason, but the practical reason was that this would mean that many asylum seekers getting this lower level of right, this temporary permit, would start all kinds of procedures for getting proper refugee status. Now, I want to approach this discussion from a legal perspective. I mean, it's a political decision how you want to. I'm a lawyer. I'm not on the Danish side. I'm not on the Swedish side. But I will look at it from a legal lens. Commonly, cessation entails the legal question whether the conditions of the cessation clauses of Article 1C of the Refugee Convention are met, and arguably the most contested issue there is whether the ceased circumstances clause can be invoked. Is the change of circumstances in the country of origin of a significant non-temporary nature? I'm more interested in another legal angle, at least today, and that is the question whether, if cessation is possible, so assuming that the conditions of the cessation clauses are met, should we then indeed revoke refugee status or allow continued residence? And in what extent is it only a political question, or are there also legal constraints, and what are the legal constraints for decision making in that respect? And I think that when a refugee lawyer, but also a policymaker, is confronted with questions of cessation, this not only involves looking at whether the person can safely return, but cessation involves all kinds of other legal issues. The person has acquired rights in the host country, has built up a family, has built up a business and so forth, and can bring in those rights in challenging a cessation decision. I'll come to that in a moment, but first, just to outline the known legal context of cessation. Article 1C of the Refugee Convention lists 6 cessation clauses. Normally we divide these into 2 broad sets. The first set comprises the 4 clauses which relate to a change in personal circumstances of the refugee, brought about by the refugee's own act of its own free will, such as voluntary return or acquiring the nationality of the host country. And commonly this results in cessation without a declaration to that effect being necessary on the part of the state. By engaging in some action, cessation automatically occurs and someone loses refugee status. So if one acquires the nationality of the country of asylum, refugee status is automatically lost. There's no separate decision to that effect needed by the state. And the second set are the ceased circumstances clauses, and these are normally invoked by the state, in which it is the state that actively withdraws refugee status because international protection is no longer required or no longer justified. These have been taken up in the qualification directive, and I mention here the directive, the recast directive, and I believe the UK is not bound to that one. But in respect of cessation, not much has changed between the original qualification directive and the recast. Article 11 of the qualification directive lists the 6 cessation clauses. The chief difference with the Refugee Convention is that the qualification directive explicitly mentions, in respect of the ceased circumstances clause, the requirements of significant and non-temporary nature of the change. Article 16 mentions cessation in respect of subsidiary protection, and there only the ceased circumstances clause is taken up. Only that is a ground for cessation of subsidiary protection. But with subsidiary protection as well, the change of circumstances in the country of origin must be significant and not temporary. In the Refugee Convention, there is also a compelling reasons proviso, we call it that way, which applies only to statutory refugees, so refugees from before the adoption of the Refugee Convention and their descendants, possibly, that's arguable. What is interesting to note for our discussion is that during the drafting of the Refugee Convention, there was also a proposal to extend this compelling reasons proviso to compelling family reasons for refusing to return. With this example mentioned by one delegate, an aged female refugee having no family members in the country of origin and who could therefore not reasonably be expected to return was not taken up. In the Refugee Convention, the adopted provision only speaks of compelling reasons arising out of previous persecution, which is commonly seen to apply to persons who are so traumatized, so disillusioned in their country of origin, permanent distrust of their country of origin, Jews originating from Germany, that they cannot be expected to return. That would cause so tremendous psychological hardship that cannot be expected of them. And the recast qualification directive has incorporated the compelling reasons proviso. It was not in the first phase directive. An important judgment on cessation, the Abdullah case, the Court of Justice of the European Union. I'll only mention it shortly because it's not central to our discussions today. Abdullah was chiefly important because it settled an ongoing discussion among refugee scholars and differences in case law, and member states approach it differently. It was the discussion whether cessation, and especially the ceased circumstances clause, should look broadly into the question whether effective protection is available in the country of origin. So, is the country safe enough to protect against all kinds of possible future risks? What is the general human rights situation in the country? Or is it sufficient for invoking cessation that we only look at the question whether there is a well-founded fear of persecution? And the Court of Justice was criticized for taking the narrow approach, but I guess, and there's criticism on that, but I guess we will have to live with it. It's unlikely that courts in Europe will, after Abdullah, follow the broader path. The court said cessation is possible if the original fear of persecution is no longer well-founded and if there are no other circumstances giving rise to another well-founded fear of persecution. So basically cessation is the mirror image of the recognition of refugee status. We apply the same standard, and you do not need to look more broadly into what the general human rights situation of the country of origin is. So this is briefly the known legal context of cessation, and there are all kinds of discussions going on there, but we will leave them out of our discussion today. Because I want to turn to the question of the consequences of cessation. What does or what should it mean for the right of residence? And I will first discuss practice and opinions of UNHCR. In EXCOM conclusion 69, it was adopted at a time which more or less marked a turning point, and when UNHCR itself said that, well, we see now that cessation is being used more often, and we need to adopt views on how and when, in what circumstances to apply cessation. So at a moment, you could say, in which the historical openness of Western countries to receive refugees was withering away, in which the Executive Committee of UNHCR noted the persistent complex dimension of today's refugee problems and underlined the possibility to use cessation, but in which it also underlined that cessation must be approached carefully. It referred indeed to the fundamental durable changes in country of origin, but it also recommended, and I quote here, as to avoid hardship cases that states seriously consider an appropriate status preserving previously acquired rights for those persons who cannot be expected to leave the country of asylum due to long stay in that country, resulting in strong family, social and economic links. And what is perhaps also good to know that EXCOM said that if cessation takes place on a group or class basis, that there must always be the possibility for each individual to have such a decision reconsidered on grounds relevant to their individual case. And in the EU legal order, this speaks for itself. It is also very clear from the Abdullah judgment that cessation always requires an individualized decision. So if we talk about general cessation, group cessation, we are really talking about an announcement on the part of UNHCR or the state that all the refugee statuses of a particular group are to be reconsidered on an individual basis. And this is, for example, what Germany did in 2003 and 2004 when it sent letters to around 20,000 Iraqi refugees in Germany, informing them that Germany intended to revoke their status because Iraq had become safe after Saddam Hussein was driven away. And one of those persons was Mr. Abdullah, who brought this case to the Court of Justice. UNHCR handbook does not really address the question how we should appreciate the consequences of cessation in terms of residence status, but it does say that a refugee status should not in principle be subject to frequent review to the detriment of a sense of security which international protection is intended to provide. So, according to UNHCR, international protection is not only about protecting against persecution, but apparently also about guaranteeing a sense of living, guaranteeing a sense of a stable and secure life. In the more extensive guidelines on seized circumstances clause, a special paragraph is devoted to long-term residence, and UNHCR says there, with respect to long-term residence, countries of asylum are encouraged to provide, and often do provide, the individuals concerned with an alternative residence status after cessation is invoked, which retains previously acquired rights, though in some instances with refugee status being withdrawn. And adopting this approach, UNHCR says, for long settled refugees is not required by the 1951 Convention, but it is consistent with the instrument's broad humanitarian purpose and with respect for previously acquired rights. And the UNHCR published a note on the suspension of general cessation declarations, referring to its own general cessation declarations and setting forth on the basis of what kind of criteria such declarations should be issued. I should perhaps say that such a general cessation declaration issued by UNHCR is not meant to have the effect of simply stripping persons of their refugee status and to start forcibly repatriating them. Such a declaration is often made in respect of refugees who have been granted refugee status on a prima facie basis, and by which UNHCR indicates that their status as refugee must cease within a specific time frame with the aim of bringing to a closure a specific refugee situation in the world. So it signifies the moment by which UNHCR no longer sees itself as responsible for providing relief and where it urges states to come up with durable solutions. And this can be voluntary repatriation, but also local integration. And in that note, it specifically addressed the question of family considerations, and it said persons with acquired rights to family unity without international protection needs should ordinarily be channeled into opportunities for local integration. Just one example of how this happens, because I think we can learn in Western countries a little bit from UNHCR strategic approaches to cessation in respect of a number of African countries, because UNHCR applies cessation on a much more regular and much more well thought out basis than in Western countries. That's one of the points I would like to make. Let us look at what happened with the general cessation in respect of Rwandan refugees, much criticized, but for reasons a little bit outside our perspective. It's criticized because it's argued that Rwanda is not at all safe for large numbers of Rwandan refugees. But in deciding that states should start revoking refugee statuses, UNHCR made 3 points. It said countries of asylum should start facilitating voluntary returns, that countries of asylum should provide for exception procedures in which a refugee can claim that he is still at risk of persecution, and that local integration or an alternative legal status should be considered. Many Rwandan refugees, UNHCR said, are long-term residents in their countries of asylum. 1/3 of them have been born in exile. Many refugees have established family ties through marriage to nationals of the country of asylum. Many are contributing to the local economy. After decades of exile, the links of these individuals with their country of origin have weakened considerably, and in such cases, an alternative legal status and not voluntary repatriation is the most appropriate solution. To conclude this slide, and about Rwanda, before I conclude the slide, you see indeed that countries in the region hosting large numbers of Rwandan refugees do often grant the possibility of obtaining all kinds of residence and work permits. One problem there is that they only issue such a permit if the person has a Rwandan passport, and Rwandan authorities often do not give Rwandan refugees passports, which is an obstacle for getting a residence type in other countries. To conclude this slide, the Refugee Convention says nothing about the right of residence, so cessation is not connected to the question of residence or return. UNHCR says cessation marks the point of concluding a protracted refugee situation, and that can mean all kinds of things, different kinds of durable solutions, and it is at least advisable when states look and apply a cessation that they take account of all kinds of other factors than only the safety of the country of origin, family life, duration of residence, social economic integration. And now let us go to EU law. Compared to the Refugee Convention, one of the major improvements of EU asylum law, the Qualification Directive, is of course that refugee status as well as subsidiary protection status entails a clear residence right. But this coupling of refugee status with residence also has the potential of making cessation decisions much more consequential. The European Commission, I think, was aware of this when it proposed the Qualification Directive in 2001. It included a provision which said if one of the cessation clauses applies, the residence permit may be revoked, so discretion on the part of member states. And in the explanatory memorandum, the Commission said on the ceased circumstances clause, the member state invoking this cessation clause should ensure that an appropriate status preserving previously acquired rights is granted to persons who are unwilling to leave the country for compelling reasons out of previous persecution, the compelling reasons proviso, but also to persons who cannot be expected to leave the member state due to a long stay resulting in strong family, social and economic links in that country. So this was not in the text, but in the explanatory memorandum, not in the text of the directive itself. The European Parliament went further and said that this should be brought into the text of the directive itself, and it proposed an amendment to the Qualification Directive which said that this ceased circumstances are a ground for cessation unless social, economic and family ties in the host country make return to the country of origin difficult to envisage. The European Parliament did not have the right of co-decision at the time, and all this fell on deaf ears in the Council negotiations. Instead, the Council did something which went into the entire other direction. It changed the May wording of the Commission into shall. If a person ceases to be a refugee status or subsidiary protection status shall be revoked, and this necessarily means that residence as a refugee under EU law is also terminated. In 2007, we had the European Commission evaluating how member states had been implementing the directive, and the Commission said revocation of status in case of cessation is phrased in mandatory terms in the directive. However, legislation in a number of member states merely allows for termination of status, and if the refugee has been granted permanent residence, the termination of status is sometimes restricted or prevented in some member states despite the fulfillment of conditions for cessation. In other words, the European Commission noted in somewhat accusing tone that many member states did not automatically couple cessation with revocation of status, and the European Commission said that it was not a proper implementation of the directive. And I believe, at least I know that in Germany and also here in the United Kingdom, the law also automatically couples cessation with revocation of status. I looked it up for you in the UK immigration rules, which says in paragraph 339A that cessation must lead to the end of refugee status. In Netherlands it is discretionary. It says in case of cessation the status can be revoked. The residence permit can be revoked. Also, important for what this means is the judgment of the Court of Justice. Just first to the recast directive, what it is changing, it did not change anything about its mandatory language, but it did introduce, upon the wish of the European Parliament, the compelling reasons for visa, so not to be returned if there is psychological hardship, but only for reasons arising out of persecution. And then to the judgment in B&D, which was a German exclusion case, a German that excluded a number of individuals on the basis of Article 1F of the Refugee Convention. But what the court said there about the consequences of exclusion for refugee status in the meaning of the Qualification Directive is also, by analogy, applicable to cessation cases. Because the argument could be made that a more favorable standard clause of Article 3 of the directive holds that, well, if you exclude someone or if you think that cessation is applicable, you can still maintain refugee status and the residence permit. Germany wanted to do that. It saw no reason why it could not maintain the status. At least in some instances, Germany wanted to do that. But the court reasoned differently. It said, if the directive says shall, it is shall. If you exclude a person, if one falls under the exclusion ground of Article 1F, that means he is excludable, and that means that the refugee status shall be revoked. You may then grant the person asylum or residence or on humanitarian grounds, but you must do so on the basis of national law outside the scope of the directive. And the reasoning for this is that otherwise the credibility of the directive protection system is undermined. The directive is only there for persons who are deserving of it or who are in need of it, and that means in the case of exclusion, but also in the case of cessation, that the directive cannot be of their benefit. In continental Europe, we have the long-term residence directive. I believe not here, right? You have not opted into the long-term residence directive. In 2011, we extended the scope of that directive to international protection beneficiaries, which more or less means that any refugee subsidiary protection beneficiary, after 5 years of legal residence, acquires long-term residence status, which is a permanent residence status. And this has consequences for the residence right of refugees because the directive has a closed system of grounds for terminating permanent residence. And these grounds see to fraudulent acquisition of status, public order considerations, prolonged absence from the member states, exclusion, Article 1F, if that is found out at a later stage, it's still possible to strip someone of permanent resident status, but cessation is no longer a ground for loss of long-term residence status, which means that there is sort of a cut-off point in EU law. After 5 years, you can acquire permanent resident status and you retain that status even if your country of origin has become safe. In other words, EU law operates under the presumption that if the protection need ends before permanent residence is acquired, the EU residence right must terminate, and member states must then either, well, apply the returns directive to that person and start procedures for getting him away or provide for status under national law, but EU law can be no relief. I think this is awkward, primarily because it simply does not correspond with the practice in a majority of member states. They simply allow most refugees to remain, even if they know very well that the country of origin has become safe, and EU law obliges them then to cease status, to terminate the residence permit, and to grant a different residence title. But of course, this is all very administratively awkward. So that is one reason I am quite displeased to see, well, why the Council in the negotiations changed this main provision into a shall. One avenue, of course, to avoid is to simply not check for cessation if a member state wishes to retain the residence status, even if this may go against the idea that the EU refugee status is only for persons who are in need of it. But I think we must now also go into the real legal discussion under what circumstances then is it possible to invoke cessation, which basically is that as soon as a person is allowed residence as refugee, that person starts building up rights in the host country, and it's quite apart from the need of protection. Determination of residence may interfere with other rights. And I've looked at Article 8 of the European Convention, especially, because this is normally where we look at when we argue that the expulsion of settled migrants comes in conflict with their fundamental rights. Now, what would happen if we decide to revoke refugee status of a Syrian refugee after he has been living for 4 years in the United Kingdom? What would happen if he brings his case before the European Court of Human Rights and invokes Article 8 of the Convention? Of course, key is what his personal situation, what his family situation and so forth is, but I think we can make a few general observations. The first one is that there is very little case law on this specific kind of situations. Surprisingly little, perhaps, on little case law of the European Court of Human Rights on the expulsion of former refugees who have not committed crimes, and this may be explained from the fact that EU member states indeed rarely elect to expel refugees who are no longer in need of protection if there are no considerations of public order present. We are talking here about an interference with the right to private and family life, and that means that the criteria as established in the Boutif case are by analogy also applicable to this type of cases. It is an interference with a negative obligation not to interfere in someone's private family life if one is expelled as a settled migrant. The expulsion must be necessary, it must be proportionate according to the court, and this in itself means that group cessation policies are problematic because one must look into the individual situation of the person concerned, family situation, duration of stay, solidity of social, cultural ties, etc., etc. In absence of a concrete case, we cannot make that assessment. It will depend on the person concerned, like I said, but if we look at a number of those criteria, we will be able to see, I think, that we are talking about a special group here, which makes the Article 8 test different than how we normally go about it. First of all, the state can probably not invoke considerations of public safety against expelling the person if the refugee has not been engaged in criminal activity. So what other legitimate aim mentioned in Article 8, paragraph 2 should the state then invoke? Probably the economic well-being of the state that has been used in other case law as well. General immigration considerations can be a reason for expelling immigrants. And you could say that in the absence of public order considerations, this may put the applicant in an advantageous favorable position. And probably the state will then have to argue that expulsion is in the economic well-being of the country. There is a more general interest not to receive too many refugees, because that is well costly business, financially or otherwise. And possibly here the state has a stronger argument if it can argue that it does not normally receive massive, large numbers of refugees as it now does with Syrians, for example, and that there are now different than before strong societal imperatives looking at the numbers to not grant permanent residence. But this then depends on the situation at hand, and I think that the state must make the argument that it is in the economic well-being of the country, and why apply cessation to this group and not to another group is relevant for the Article 8 assessment. Can the state demonstrate that it is indeed necessary not to automatically prolong the residence of refugees? The length of stay is also an ordinary criterion to be tested under Article 8 in this type of cases. Well, I don't know how it is here in the United Kingdom, but in those countries bound by long-term residence permit means that expulsion is only possible within the first 5 years of legal residence. How is it here in the UK? When is permanent residence acquired by refugees?
In some cases you can apply after 5 years. In others you have to have had 2 periods of 5 years. And it seems to me that one of the things that I have seen is that long-term clients who have been here for those periods then apply for naturalization and are refused a passport on the basis of, say, for instance, having had a traffic offence or a point on their driving license. So there is in my view, there is a bit of active searching going on for reasons not to grant the permanency that would arise from being allowed to naturalize. Yeah. It is also the case that people who have been granted status since the change to a 5-year period of refugee status with a possibility of a review with a view to cessation are, in my experience, being prejudiced in finding permanent work, in finding housing, and therefore there is a self-fulfilling reaction going on against integration, which I think in the current climate is extremely unhelpful.
Normally, I would think that, especially if you look at the examples, for example, in Germany and the Iraqi cases, that those are refugees with group cessation is applied who are only present for a few years. So in those kind of cases, the criterion of length of stay doesn't work in favor of them, but that can be different in all kinds of specific other situations. And another interesting criterion, I think, in the case of the European Court of Human Rights, is that it often attaches importance to the question whether the immigration status has from the outset been precarious. If it is known that, if you've entered the country illegally, never acquired a legal status, and you start building up a family life, you start working, and then the court says, well, you start building up a family life, you start to integrate in society, knowing that your immigration status is precarious, and therefore your interests weigh less in the balancing act. And how should we approach this when we look at refugees who have been accepted into the country? Do they know from the outset that their immigration status is precarious? Strict legally, I think in most member states, not in Sweden, their status is from the outset temporary. But the practice, it would seem, in many member states is that there is this automatic practice of allowing permanent residence and naturalization for large groups of refugees. Moreover, the states offers all sorts of integration programs, language programs, does not really send out a signal that residence is only meant to be temporary, and can you then reproach the refugee for starting to integrate in society, for starting to build a family. One could take this point further by saying that if a member state really wants to return Syrians as soon as possible, if Syria has become safe, it is perhaps, if they want to win their cases under Article 8 of the European Convention, best if they take the Danish approach. Make it clear for specific categories of refugees, Syrians fleeing from civil war, from the outset make it clear that they cannot stay indefinitely until some cut-off point is reached, and not leave it hanging into the air, not giving all kinds of vague signals, undecided, and simply, well, after 3 years send them a letter that their status will be revoked, which they would never have thought of when they first arrived and got their permit. And this is what the Germans did in respect of the Iraqi refugees. Let me now move to some preliminary conclusions. My research is still work in progress. This is more or less my desk research. I already have had some interviews in the Netherlands with persons working with the Immigration Service, and what I really want to know is I want to go into the member states. I want to go to Sweden or to Denmark, to Germany, also to this country, to see in what type of cases cessation is invoked and in what type of cases not. My preliminary impression is that cessation is really arbitrary business. And I've seen in the Netherlands that cessation is often used in cases where cessation is the easiest way to get a criminal refugee out. Where it's very difficult to prove that someone has been engaged in criminal activity, or that the Article 8 test that someone is not really engaged in serious crimes. But then the easy way out is to say, well, we now look at your country of origin, it has become safe, and this is the easiest way to get rid of your residence title. And I want to make the point that although cessation may be arbitrarily applied, there are all kinds of legal constraints also outside refugee law. And I discussed Article 8 of the European Convention, and I think we can think of other legal constraints as well. So especially group cessation, with the impression that you can get an entire category of nationals out of your country is out of the question, because it has to be individualized and has to be looked at the individual circumstances of each refugee. Cessation, therefore, in my view, requires vision and policy. At least at two moments. First is right at the beginning. If we let someone in, what do we want with this person? If he behaves good, if he does not breach the law, can we say, give him the message that he can stay in permanently? And we can debate on whether the Danish approach or the Swedish approach in respect of Syrians is better, but the good thing about these two countries is that they make a choice beforehand, and that they send out a clear signal to the person. And for example, the Danish say you cannot apply for family reunification in 1 year, and that is because your stay here is only meant to be temporary, and that means that your family won't be broken up for the rest of your lives. And so make it clear to refugees from the outset when and how possible checks for cessation are made, if they are made at all. And in implementing cessation, so we have seen that the country has become safe. I think we can learn quite a lot from UNHCR strategy of general cessation declarations in respect of refugee situations in Africa and Asia. I mean, cessation is accompanied with multiple durable solutions, not only focus on repatriation, but also on local integration for specific categories of refugees, and this also matches what is required by Article 8 of the European Convention on Human Rights. I'm not in favor of cessation, but I'm also not against it as a legal possibility, and if it is the case that you see a trend among states that cessation is used more often, I hope that my research will contribute to removing a bit of arbitrariness from it, and that I think is the key point of my presentation today.